This is Michael Popok, Legal AF After Dark. We needed all three anchors to handle the amount of new information, mainly bad, against Donald Trump just this past week. Now we're talking about what's going on with the Manhattan DA's office. Why is there a trial on March 25th? What's that trial all about? Did Judge Chutkan, who's down at the DC trial court level, federal court, did she talk to Judge Merchan, the New York State Supreme Court judge, before Judge Merchan set the March 25th Stormy Daniels hush money business record fraud case against Donald Trump? Would you like to know? Well, we're about to tell you. Watch this clip.
Let's, though, switch gears and talk about what's happening in the Manhattan District Attorney criminal case against Donald Trump. There was a hearing earlier this week. We talked about the prospect of this trial date actually being a real trial date and not just a prospect. Karen, you said it's going. I'm not sure why anyone's debating it. It's scheduled for March 25th, 2024. I know a lot of people are thinking maybe because they just have fatigue with all trial dates moving. You said, no, this date's going. And Donald Trump showed up at this hearing. Manhattan District Attorney's team showed up, and right away, Justice Juan Merchan, very forcefully rejected the motions to dismiss that were filed by Donald Trump and said, no, we're going to trial here. Karen, break down what took place at that hearing.
So if you remember this case, after Donald Trump was arrested and arraigned in court, Judge Merchan set a bunch of trial dates so that everyone would know what to expect, when certain things were due, when to come back in court. And he said, I'm going to set March 25th as a trial date, but I want to set almost like a control date in February to come back and let's just see what's going on to see if we're really going to go March 25th. And the reason is because there were other cases that were also competing for court dates, right? And there was a time when Tanya Chutkan's trial we thought might go in early March, which is now on pause in terms of when that's going. And so Judge Merchan wanted to kind of touch base, if you will, in mid-February to see, okay, is the Tanya Chutkan Washington, D.C. Jack Smith case going? If it is, then we'll move the March 25th date because you definitely couldn't fit both of those in. And so that's what this was for, was to see, okay, are we really going March 25th? I think people thought, or Donald Trump pretends like he thought, that maybe there was going to be some discussion about whether the case is going in March 25th. That was not what this date was for. This date was not to see whether it's going because somebody doesn't want it to go because there's a presidential election. It was, is there going to be a conflict with Judge Chutkan? And as soon as we saw that Judge Tanya Chutkan took March 4th off the calendar, I thought she did that to send a message to Judge Merchan, there is no trial date March 4th. So she took that off the docket. Judge Merchan could look at that public docket and see, okay, that trial's not going, and told the parties it's going March 25th. And so it was clear to me even before then that that's what was going to happen. And so that was set. And the people said they will be ready, right? The Manhattan DA's office. Also, Alvin Bragg has staffed up the team to be ready for trial. They put one of the most respected trial lawyers in the Manhattan DA's office, Josh Steinglass, to be a part of the team. Josh is his title is senior trial counsel. That's the most prestigious position in the office. It's not a title given away lightly. You have to be somebody who is very, very experienced as a trial lawyer. He comes from the trial division, and I worked with him closely, and he's one of the go-to people. He's also the trial lawyer who successfully convicted the Trump Organization, along with the other trial team members, also equally excellent, Susan Hoffinger and Chris Conroy. This was the team that convicted the Trump Organization of 17 counts of tax fraud in November of 2022. And so that was something that that was really smart, I think, of Alvin Bragg to do, was to put him on the team once they knew the trial was going. And so then the other thing that happened at the hearing, or at the court date, was a ruling on all of the motions, the substantive motions. And so what in New York, the way we practice is you put all of your motions in one giant omnibus motion. You don't do it piecemeal. And so any motions, any requests, a motion is just you're asking the court for something. So any requests, any motions that the defense had, they are supposed to put it in this omnibus motion. And then the what happens next is the people respond with their opinion or their position, I should say, on the motions. The defense can reply to that, and then the judge makes a decision. And that's what this court hearing was for the judge to decide these substantive motions and determine whether there were any evidentiary hearings necessary where you would call witnesses to determine whether or not certain things are what they are. So the judge denied every single one of the defense motions here except one. So the motions that were made were by Donald Trump and his lawyers were basically that the statute of limitations had run because it was more than 5 years. There's a 5-year statute of limitations. There's more than 5 years had passed since the crime occurred and the charging occurred. And however, it's very clear in the law that Andrew Cuomo, the governor of New York, pressed pause on the statute of limitations during the pandemic for every single criminal case, I should say, not just for this case. He basically said the courts are closed for, it was like almost a year or around a year. And so they pressed pause on the statute of limitations. That on top of the fact that Donald Trump was outside the jurisdiction while he was president for most of that time, tolls or pauses the statute of limitations. That's basic law 101. Made the argument anyway, so there was no doubt that that was going to be denied. A couple other areas that Donald Trump tried to make hay out of was they claimed that there was a violation of grand jury secrecy, that the peoples haven't turned over all the discovery, all that kind of stuff. That was just frankly nonsense, and the judge summarily dismissed that as well. The only somewhat substantive ruling that Merchan made that went in favor of Donald Trump and against the DA's office had to do with, if you remember, Donald Trump is charged with falsifying business records in the first degree, 34 counts of that. And in order to make that a felony, there are two types of falsifying business records in New York. There's misdemeanor falsifying and felony falsifying. And all a felony is the falsifying plus you did it in order with the intention, right? You meant to, not that you did, and that's important, that you were meant to, that at the time that you were doing it, you intended to conceal or commit or aid the commission of a crime. So the way I always describe it is it's like burglary versus trespass in New York. Burglary is nothing more than trespassing plus the intention of committing a crime. And a perfect example is somebody breaks into your apartment, and he comes in and he's carrying a sleeping bag and a pillow and goes and lies down on your couch and goes to sleep. You call the police come and they say, "Sir, you're not supposed to be here." He says, "I'm tired. I needed a place to sleep." Frankly, that's only a misdemeanor in New York. It's a trespass because he didn't have an intention to commit a crime. If that same burglar broke into your apartment and instead of carrying a sleeping bag, a toothbrush, and a pillow, he was carrying a safe cracker, handcuffs, and condoms, and he steps into your door at the same time the police are walking down your hall and miraculously see him, and so they arrest him before he can commit any of those crimes, you would charge a burglary. And because he was trespassing, and you would argue he had an intention to commit a crime. However, you don't know. Was he going to break into your safe with a safe cracker? Was he going to tie you up because he had handcuffs? Was he going to rape you because he had condoms in his pocket? You don't know which crime, but you can certainly make the argument and charge and prove beyond a reasonable doubt to a jury that that person intended to commit a crime therein, even though he didn't actually commit a crime. There was that intention. And so when you put that layer that onto falsifying a business record in the first degree. It's what did they intend when they were falsifying those records? And the people, the Alvin Bragg's office, their theory is that there are 4 different crimes that they're alleging he intended to commit. They don't have to prove that anyone did it. They don't have to prove the elements of the crime, just that he intended to do it. And the 4 crimes, what Alvin Bragg's, or what Judge Merchan ruled was, I found that 3 of those 4 were sufficiently presented to the grand jury that those are the theories that the government can go with. One of them, there was not sufficient evidence presented to the grand jury to do that. And the 3 are the federal election campaign violation, a state election campaign violation, and tax crimes, which frankly I think is probably the easiest one to prove, because they grossed up Michael Cohen's repayment so that it could look like income instead of repayment for hush money, this election, so that you could suppress information from the election. And the only one that they said there wasn't sufficient evidence was they said that they basically said it was too far afield to argue that AMI, that Donald Trump and Michael Cohen conspired to do this in order to make AMI also falsify their business records, and that was the intention. And so it's the only thing that Juan Merchan said, you know what, I'm going to give that, I'm not going to let the government argue that was one of the crimes. So other than that, it was an across the board rejection of all of the things that Donald Trump said, asked for. And Judge Merchan went through all the arguments. Donald Trump said that there was no intention to defraud anybody, and there was no selective prosecution, and there's no statute of limitations violation. So all of those were rejected by the judge, and that's what happened on at the hearing this week, and the case is going to trial.
And Karen, a lot of people want to know, if Donald Trump is convicted here, are these the types of crimes, though, that could potentially have a prison sentence? Is it what's the degree of the crime? And assuming Donald Trump is convicted on all 34 counts, what happens next?
Yeah, so this is in New York, their felonies start with an A, which is the highest level. So murder, for example, is a class A felony, and then it goes class B, C, D, and E. So this is a class E felony. It's the lowest level felony, which means the judge has complete discretion here on what to sentence Trump. He could sentence him to probation. He could sentence him to a fine. He could sentence him to community service. He can sentence him to just a conditional discharge, the condition being that he just doesn't commit any other crimes. I mean, the low end is quite low. The high end, however, he can get up to 4 years, an indeterminate sentence of 1 1/3 to 4 years. And some of those could even be consecutive to one another. So he could serve actual prison time, especially at his age. That could be a life sentence. So it just depends on what Judge Merchan finds when he looks at the sentencing and the sentencing factors. If his name wasn't Donald Trump, and he wasn't the former president, and he wasn't guarded by Secret Service, and he was just your average Joe who committed this election violation and then tried to steal another election, and was somebody who stood before the court as a convicted felon, if he's convicted after this, with 3 other open indictments in 3 other jurisdictions in both state and federal court, I would guarantee that he would be incarcerated and put in, and he would probably be given a very high sentence, probably the maximum sentence that could be given to him, because this is still a serious crime. It's a felony, and not many defendants, especially in the white collar world, which this is a common white collar charge that is charged all the time in New York. This is not some unusual charge. Most white collar criminals actually don't have a rap sheet. It's usually, they don't usually get caught. I don't know of any that had 4 indictments in 4 jurisdictions, both in state and federal court. So if you were to just anonymously, if his name wasn't Donald Trump, and you were just to look at how someone would be sentenced, he would be, if the jury found him guilty, he'd be put in. He would be walking. I would be telling my client, bring your toothbrush on the day of the verdict, because you're going in if you're convicted. But that will not happen. If it was your
client, I'd be telling him, you got the best lawyer in the biz.
Well, anyway, so that's what could happen. What will happen? Judge Merchan is not going to put him in before the election. It's not happening.
That's Karen's prediction, although he does have discretion, to be clear, to sentence Donald Trump to up to 4 years. That's within his discretion, correct?
So, yeah, I mean, I can't think of a better person to cover what happened in the Manhattan DA's office than the almost never wrong Karen Friedman Agnifilo. I use that same phrase for us, Ben, especially about things. She and I had a little bit of a debate a couple of midweeks ago about what that conversation between Judge Chutkan and Judge Merchan was going to result in. There is reporting, as I predicted, that they did speak. Their chambers spoke, which they're allowed to do, for those that are wondering, under the rules of judicial conduct. They had spoken before when he graciously decided originally to step aside for her if her trial was going to take place on March 4th. No, there wasn't going to be simultaneous criminal trials of Donald Trump, a fact that the Judge Merchan reminded the lawyers for Donald Trump, which were really led this time by Todd Blanche, against the Manhattan DA's office. He reminded him about that. But there was another conversation. And it was the posting, of course, where Judge Chutkan signaled, I can't do this trial the beginning of March because of the appellate issues we're going to talk about next through Ben, about whether the Supreme Court would or would not take up the appeal on the immunity issue. In the meantime, her case is stayed, and so she did signal that. But there was a conversation. And based on that conversation, and I want to talk about the ramifications of that conversation in terms of that trial setting, then the judge felt very comfortable in saying, yeah, we're going March 25, which did apparently, to Karen's point, catch Todd Blanche flat-footed, because he thought, even though he was there at the beginning of the arraignment, it didn't come late to the case like some people. He said, oh, I thought we're going to talk about whether there's going to be a trial in March, and things have changed now. There's a election and there's primaries. And by the way, none of that changed. Donald Trump was obviously going to be running and was going to be the leading candidate for the Republicans, and there was going to be primaries. So I don't get what Todd Blanche's point was. And the judge told him to sit down, Mr. Blanche. And there was a number of places where the judge is reported to have reached loggerheads with Blanche. There's the both of them there, and basically told Todd Blanche, sit down. This is not the purpose of this. And now let's get to your motion to dismiss the indictment, which, as Karen went through methodically, he rejected each and every one of them. And then he said, it quickly shifted to, let's talk about questions for the jury. And that also caught Todd Blanche flat-footed, and he kept saying, "But he may be the president and all." And he said, What is your legal argument? I mean, that's your rhetoric. That's your political rhetoric. What is your legal argument as to things like Todd Blanche suggesting that the case has to be moved out of Manhattan? We need to have a cooling off period because the E. Jean Carroll case just happened in a federal court about different issues in the civil case, and that's still vibrating in the city. Which, by the way, it's not. Living there, it was an important decision, but it's not something that people are talking about every day. It's going to infect the jury. We got to talk about jury questions, and so they were not prepared. And the other thing they were not prepared for, the lawyers, which doesn't surprise me, is that, as we've said before, and Ben and I and Karen all together, this trial team for Donald Trump, which consists of 4 people, not 4 law firms, 4 people, supported by like 2 associates apiece and a couple of paralegals, is really thin. and they're getting stretched thin. And they raised the issue of, but we have this, and this was interesting because this was a bad admission for Todd Blanche in the heat of battle that'll come back to haunt him. He said, but we've been preparing for the DC election interference case, Your Honor. And he said, well, first of all, that is completely inconsistent. And now it's going to be brought up by Jack Smith. That's completely inconsistent with the stay that's been in place by Judge Chutkan and by the DC Court of Appeals, so that he did not have to prepare while the immunity issue is being resolved. But Blanche said, we've been focused on it because it could have went to trial in March. And the judge basically, without commenting on the inconsistency of the position, he'll leave that to Jack Smith to take up in his various filings. But he said, the fact that you guys are the lawyers in both cases is of no moment to me. He perhaps should have had different lawyers representing him in different cases so that you're not stretched so thin. But let's move on. And so again, shot down Blanche again. This case, as Karen predicted, based on all this data points, is going to trial for about a 6-week period in March. We're going to have a jury verdict well in advance. And then I'll leave it on this. This means if there's a requirement basically for due process purposes, for there to be a sufficient gap between one trial and the other to give this overlapping trial team time to get ready for the trial in the DC election interference case, then if this case for Stormy Daniels hush money cover-up case ends by May 1-ish, which is 6 weeks from March 25, give or take, then we're probably looking at, forget April and May for DC election interference. We're looking for June, likely July for the case of the Chutkan case, depending upon the results of the Supreme Court immunity issue. And that's right where Judge Chutkan anticipated, because as we reported on Legal AF, in another hearing involving Jan 6 defendants, she said, I plan to be out of the country in July unless I'm trying another case.
So what looks like could happen is you have the Manhattan District Attorney case goes to verdict sometime, if the case starts March 25th, you go through jury selection. Karen, when would you say? May, mid-May, end of May, or sometime around
6 weeks, the judge.
Yeah, 6 weeks. And then you can potentially have a short gap, depending on what the Supreme Court does with respect to the Washington, D.C. federal criminal case that's now working its way through the appeals processes on Trump's claim of absolute presidential immunity. You could potentially go right into the next case that summer. Donald Trump may already be convicted of a felon Donald Trump, then maybe going into the Washington, D.C. criminal case. One other thing I want to point out just to round out our coverage on the Manhattan District Attorney case, and you kind of mentioned it there, Popok, with Trump's lawyers not thinking ahead and saying things in one court that are harming their arguments in another court. Kind of all of the statements that Donald Trump's made in the past, it's not like you get the Men in Black wand and you get to erase the things that he said. As we've always been covering here, Donald Trump creates a lot of evidence against himself that prosecutors and lawyers would love to get out in a deposition, and Trump just posts it. So remember this post that Donald Trump made in that March 2023 period we were covering when the indictments were going to drop by Alvin Bragg? Here's what Donald Trump posted. I did nothing wrong in the Horseface case. I see she showed up in New York today trying to drum up some publicity for herself. I haven't seen or spoken to her since I took a picture with her on a golf course in full golf gear, including a hat, close to 18 years ago. She knows nothing about me other than her con man lawyer Avenatti and convicted liar and felon jailbird Michael Cohen may have schemed up. Never had an affair with her, just another false, and then Trump writes, acquisition by a sleazebag, which, well, we would expect Stormy Daniels is going to be a witness in this case. And these posts may come up. What I found interesting is, I'm not sure if you caught this, though, at the very end of the hearing, Donald Trump's or the Manhattan District Attorney said, trial may last an additional 2 or 3 days because Trump refuses to stipulate to the authenticity of his own messages. So they have to call in custodians of records to try to bring in or to show that these were sent by Donald Trump and when they were sent by Donald Trump. So it becomes admissible evidence. You know how Alina Habba didn't realize in the E. Jean Carroll how you have to admit evidence and it has to be admissible and you have to establish a foundation. Well, Trump's not stipulating to the authenticity of his own messages. So they'll be able to get it in. It's just going to take an additional 2 or 3 days to do that based on all of the stuff they need to get in.
Well, that was Legal AF. We do a show like that every week, Wednesdays and Saturdays at 8 p.m. Eastern time, right here. Don't change that dial, the MeidasTouch Network. And we sit at that intersection of law, politics, and justice. So if you like shows about law and politics, U.S. style, by lawyers who know what they're talking about, you've come to the right place. We call it Legal AF for a reason. It's exactly what you think. And there you got a taste of all three anchors. We usually have 2 of us at a time on Wednesday and Saturday, but what a week we had to get together and just do it all together. So if you're already part of our audience, thank you from the bottom of our pod. We really do appreciate you being here. Take that clip, send it off to others in your life who may not know anything about us and say, you know, that show I watch, my guilty pleasure, Legal AF, join us, join them, take a listen. And then maybe that'll get them over to join. If you have no idea what I'm talking about, who is this guy? I'm Michael Popok. That was Legal AF, and we invite you to join our audience. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.